Okay, good afternoon again, everyone. My name is Chris Greising. I'm with the Industrial Minerals Association. I'd like to welcome everyone to today's webinar, Between a Rock and a Hard or Special Place, Cultural Resource Considerations for Mining Projects. We are very pleased to have Merritt Fredrickson with us from our friends over at Holland and Hart. Just want to quickly go over the ground rules for the webinar. All of your lines are muted. If you have questions, I encourage you to type them into the questions box that is on the GoToWebinar software. At the conclusion of the presentation, we will relay those questions to Merritt, and then the other thing is that the webinar is being recorded. We will get you guys a copy of the recording and the PDF of the slides, hopefully by later this afternoon, if not by Monday at the latest. And with that, I will introduce Merritt. Ms. Fredrickson counsels energy clients on local, state, and federal environmental compliance with particular experience in environmental audits, local permitting, and Section 106 of the National Historic Preservation Act. She frequently advises clients on tribal consultation issues pursuant to the NHPA and other federal statutes, the scope of federal agency review, and other aspects of the Section 106 process. And she assists clients in the development of programmatic agreements. She has successfully conducted and managed environmental audits in response to whistleblower allegations. Ms. Fredrickson advises a wide range of industry clients through the often unexpected regulatory hurdles presented by local governments. Her practice is designed to assist clients from cradle to grave as and before environmental and permitting issues arise throughout the life of an energy project. In addition to initial advising and permitting for energy projects, Ms. Fredrickson's administrative practice includes defending projects through the BLM State Director Review process and before the Interior Board of Land Appeals. She also appears before state regulatory agencies and in state and federal courts. She has assisted clients in projects throughout Wyoming and in complex interstate development projects, including pipelines. Ms. Fredrickson also has experience in Native American gaming issues, eminent domain, and public utility and telecommunications regulations. Prior to pursuing a legal career, Ms. Fredrickson managed a small company in Jackson, Wyoming, with a team of up to 55 employees. Prior to joining Holland and Hart, she interned with the Water and Natural Resources Division of the Wyoming Attorney General's Office and is licensed to practice law in Wyoming and Colorado. Thank you very much for being with us today, and I turn it over to Merritt.
Well, thank you very much, Chris, for that kind introduction, and thanks everyone who's joined the webinar. And I also just want to thank the Industrial Minerals Association for asking me to share this presentation today. Cultural resource management is one of my favorite practice areas, and for some great reasons that I actually have a slide for. I want to point out that on the cover page of the slides, we have a picture of a trona mine on the left, and this is a publicly available photo of one of the mines in southwestern Wyoming. And then on the other side is a teepee ring, and this teepee ring is in Fremont County, Wyoming, which, if you just think of Wyoming as a big square, this is somewhere in the middle of the state. So we're stuck somewhere between a rock and a special place, and we have plenty of rocks coming out of underground resources, and then a teepee ring. This is a pretty significant and large teepee ring on public land. And you know, how do we navigate the suite of cultural resource laws that affect any mining project? Why cultural resources matter for mining projects? Cultural resources law has really gained a lot of traction in recent years, not surprisingly through litigation as one of the vehicles. In particular, one case from the Southern District of California has changed the scope of Section 106 consultation, and we'll talk about that as a case study. The reason that cultural resources are important from a litigation perspective is because one of the first types of relief that a project opponent could obtain is injunctive relief. Filing a lawsuit is pretty easy, and a few weeks later you can move and have a hearing on a temporary restraining order or preliminary injunction. And if in the event that happens, I'm sure everyone is well aware that injunctive relief halts your project, halts all of your contracts. If you have contractual obligations for delivery, those contractual obligations can no longer be met. If you had teed up contractors to construct components of your project, those contracts are also on hold. And then, as we'll see in one of the case studies, having an injunction on your project while cultural resource issues are then remanded back to a federal agency causes a delay on the scale of years and can ultimately result in financing barriers. And when you have financing barriers, you can kill your project or end up with a company selling that asset to another company and changing that project. There's also, of course, the cost of litigation. And I know it's not very lawyerly to say this, but I would much rather see people not spending money on litigation. I'd rather see you guys spending money on, giving safety awards and environmental compliance awards inside of your company, or fighting other types of regulations, say Clean Air Act regulation or legislation that is particularly onerous. Cultural resources is actually a pretty straightforward area of the law to deal with, and so it's unfortunate to see companies get wrapped up in cultural resource litigation, because with careful planning on the front end, many of those litigation costs can be avoided. Notwithstanding litigation, without planning for cultural resource compliance early on in your project, you can end up with a fair number of permitting delays. And as with any delay, delays cost money, as we talked about before, with construction contracts or contracts for delivery. Any delay can really add up in pretty big numbers pretty quickly. And finally, several of the cultural resource programs that we're going to talk about today include provisions for civil and, in some cases, criminal penalties. And the civil penalties can also result in the forfeiture of equipment and vehicles, which, when you're talking about maybe a 1-ton truck, that's okay, but when you're talking about more significant mining equipment, forfeiture could also add up in a hurry. With respect to criminal penalties, where large companies are concerned, whether not criminal penalties can generally be found if there's a knowing violation of the law. And in companies over a certain size, whether that knowledge can be imputed up the corporate ladder to, say, the officers and directors can be a very big deal. Again, incurring significant legal fees while you sort out who knew what and whether or not that knowledge can be transmitted to the officers. Okay, so this is why I get so excited about cultural resources law. What is the big driver here? We have a lot of laws out there. We have environmental compliance laws for the Clean Water Act and the Clean Air Act, and we have waste regulations for solid waste and hazardous waste. But the driver for cultural resources are actually these people driving these teams of mules across the country. They drive around and they tweet, and now they're on YouTube. Okay, that was a terrible joke. Obviously, this is a movie still from an older film, but it really does hit on what we're talking about. Cultural resources trigger interests that run very deep in everyone. This next photo is an Oregon trail marker, and it's got a terrific American flag next to it. And cultural resources laws kind of stem from this very romantic sensibility. The cultural resources trigger memories of history and maybe deeply ingrained remnants of America's manifest destiny. Historic trails, as this is an Oregon Trail marker, is one type of cultural resources, and developing projects on public lands, particularly in the West, you have historic trails in quite a few places, and if you want to install a mine or mine infrastructure near a trail, you may end up with an issue because a person standing on a trail enjoying, reminiscing about what it must have been like to be a pioneer and to push a handcart across the country, that person exploring that very personal and historic experience maybe doesn't really want to see a mine in the distance, or the air emissions that are associated with that mine, or moving out of the mining industry, they don't want to see transmission lines or pipeline construction before pipelines are reclaimed completely. So what we're talking about when we talk about cultural resources are these very deep historic things that we learn about when we're in elementary school. This next photo is a picture of the field Gettysburg, where the Great Battle of Gettysburg occurred. You'll notice that a lot of the photos throughout these slides are from the West, so this photo from Gettysburg is, I think, the only one from the eastern side of the country. So we're talking about history, we're talking about this very romantic sensibility, and then we're also talking about spiritual concerns. This is a photograph of the medicine wheel located in the Bighorn Mountains of Wyoming, which are in northern Wyoming. We call it the medicine wheel here, but I want to be clear that it's just a medicine wheel. There are medicine wheels throughout the country. And they were built by Native Americans, and they have spiritual components. They're often on very tall places. And my next slide, the next photo, is San Francisco Peaks, which is a case study that we have towards the end of this webinar. If you live in Arizona or you've been to Arizona, this is also where Snow Bowl is. And when we talk about cultural resources, sometimes we're talking about landscape-sized resources. And the San Francisco Peaks are an example of a landscape-sized resource that has deep spiritual connections with a group of people in that area. And because of that spiritual connection, very expensive litigation that occurred for many years recently gave us some more tools to learn about as we plan to deal with cultural resources. Here's an outline of today's webinar. We're going to cover these programs, Section 106 of the National Historic Preservation Act. Of all of the cultural resources statutes and regulatory programs, Section 106 is likely the most time-consuming. It gets the most attention. It has the most consultation obligations. We'll also talk about ARPA, NAGPRA, and HADPA, state laws, and then at the end, as I mentioned, we'll talk about landscape-sized cultural resources and the statutes that affect those. So what are cultural resources, really? I mean, we just saw a picture of Medicine Wheel, we saw a picture of Gettysburg, but we've also got all kinds of other things, not necessarily landscape-sized things, but also pottery shards and teepee rings and baskets and lithic scatters, which, just going backwards for a moment, the photo here is a diagram of how one makes a stone tool. That flake on the bottom left, that flake would end up on the ground after someone has made a tool, and if there are enough of those flakes, then you have what's called a lithic scatter. Okay, so what are cultural resources? Well, cultural resources is the biggest family. It's almost any type of location or evidence of human activity, occupation, use, identifiable through field surveys, historical documentation, or oral evidence. And so as I mentioned, it would be lithic scatters, it would be pottery shards, it would also be old buildings. If anyone has ever been to Chaco Canyon or similar Anasazi ruins in the American Southwest, those would be cultural resources. And then we also have historic properties, which are actually a subset of cultural resources. And historic properties are a Section 106 phenomenon of any prehistoric or historic district, site, building, structure, or object included in or eligible for inclusion in the National Register of Historic Places, And we'll go into that in some more detail as we talk about Section 106 of the National Historic Preservation Act. For any history buffs out there, the NHPA was passed in 1966, which is a few years prior to the passage of the National Environmental Policy Act, our good friend known as NEPA. And there are some archaeological academics who have explained that the NHPA actually was the predecessor and served in part as a model for the NEPA statute passed a few years later. And the interesting similarity is that Section 106 of the NHPA really focuses on consultation and the consideration of other views so that we can make the best decisions possible by communicating and consensus building, much as the NEPA process engages in public comment. And we know from case law that in NEPA you can do any project as long as it was thoughtfully considered. Section 106 of the National Historic Preservation Act similarly is a procedural statute that requires you to make a thoughtful decision. This is what it really requires in yellow, that all federal agencies must take into account the effect of their undertaking on any historic property. The language here matches the definition of historic property that we covered on the previous slide. The photograph here on the bottom left is the Carissa mine in Wyoming, in the middle of Wyoming, again in Fremont County. It's an old mine that was actually closed several decades ago and is now a historic property all by itself, and it has been restored and will soon be open to the public as an educational opportunity and also tourist opportunity. So I think it's a little bit ironic that when we talk about mining, we have old mines that are actually historic properties, and yet today we're talking about how to comply with cultural resources laws for actual mining, not old closed mines, as this photo represents. So that slide, that a federal agency has to take into account the effect of its undertaking. Well, what does that mean? What is an undertaking? And why do we need to talk about federal agencies? An undertaking is a pretty broad thing. If your project, your mining project, whether that is the construction of a new mine or the construction of a right-of-way for a pipeline servicing that mine, or even getting right-of-ways for access roads, any project or activity that needs a federal permit or a federal license or any kind of federal approval would qualify as an undertaking, and that's what the third bullet down defines. If there's a single dollar of federal funding involved in a project, then it would also be a federal undertaking. For the most part, what we're talking about with mining is anything that requires a federal permit, license, or approval. The fourth subsection here, D, those that are subject to state or local regulation pursuant to a delegation of authority. It's a little bit tricky. At its face, it looks like when you get a state-issued National Pollution Discharge Elimination System, your NPDES permit under the Clean Water Act. On its face, this regulation looks like that would also require Section 106 compliance, but there are cases out there that say that's not how this was intended to be applied. So when you get a state-issued Clean Water Act permit, you typically do not need to comply with Section 106 unless, of course, there's some other federal nexus. Going back up to the first bullet, the Section 106 process is set forth in the Part 800 regulations. And these regulations were promulgated by something called the Advisory Council of Historic Preservation. But other agencies can have their own Section 106 regulations, and one of those of note is the Army Corps of Engineers, who promulgated their own Section 106 rules for everyone to comply with. But of note, when applying the rules of another agency that are not promulgated by the ACHP, ACHP doesn't really like the other agency's rules. So there can, from time to time, be a little dispute where you have complied with one agency's rules, and at the very end, ACHP says, well, we really don't like that, you know, we're skeptical that you really complied with the law because you complied with theirs and not ours, and you know, that agency B's rules aren't really the same as ours. So that's something to be aware of. In particularly complicated projects, and mining is a terrific example of that, where you have multi-year mine plans, or for other reasons, mine plans that are complicated and have many components, then it may be appropriate to execute a programmatic agreement, which is you and whatever agencies you're working with setting up your own Section 106 rules. So rather than following the step-by-step process laid out in these Part 800 regulations, you would set out similar rules in the spirit of those rules, but you really get to make them fit your project. And so, for example, if you have a multi-year mine plan that's going to cover 4 square miles, you might not want to do a cultural resource survey of all 4 miles all at once. You might want to do the part you're planning to mine next year first, followed by the following year, and you can set all of that out in a programmatic agreement. One hang-up that often comes up, and I've answered this question repeatedly, is that the Section 106 process applies on private land in addition to federal land. The key trigger is if there's an undertaking, so if there's any nexus with a federal permit or a federal license. So for example, if you're doing a right-of-way for a mine access road or a pipeline to get either water to your facility or waste out of your facility, that right-of-way might be crossing entirely public land, but if it's going to cross, for example, a water body, a water of the United States, then you need an Army Corps of Engineers Section 404 permit. That would be sufficient to trigger the Section 106 process. So when we talk about the Section 106 process, what is it that we're really talking about? Well, once the federal agency you're working with, even if it's a tiny component of a much larger project, like you have a 404 permit, that agency is going to want to identify all the consulting parties. So you're going to have a group of people identified at the front end. Then you're going to identify historic properties that might be affected by your project. Then you're going to assess the effects of your project on any of those properties. And if those effects are considered adverse, then you're going to want to develop a way to minimize or mitigate those effects. And then at the very end, you're going to write an agreement called a Memorandum of Agreement, or an MOA, or in the alternative, you may have a programmatic agreement. Once you have that agreement, you want to provide the ACHP an opportunity to participate and comment on that agreement. What happens throughout each of these steps is consultation. And so if there's one thing that you take away from the whole webinar, it's that cultural resource law requires consultation with other people. And that's that by engaging in consultation, making that consultation effective, and documenting it in the administrative record, that's the #1 thing that you need to do to comply with all of the statutes that we talk about today. So who are the consulting parties? Well, the first one is the State Historic Preservation Officer. The National Historic Preservation Act, it did several things, and one of them was establish one State Historic Preservation Office in every state, and there's a head of that agency. Tribes were given the opportunity to establish a Tribal Historic Preservation Office and officer. Many have, some have not. If there is, it's pronounced TIPO. If there is a TIPO, then they serve in the place of a SHPO. Another consulting party is you, the project proponent. Other agencies, if there are multiple agencies, I'll give an example. If you have the Army Corps of Engineers needs to do one tiny piece of a permitting project, and then the Bureau of Land Management also is one of the agencies you're working with. Each of those agencies has to comply with the Section 106 process. and they can designate one or the other to be the lead agency. That designation should be in writing, and it needs to appear in the administrative record. If it doesn't, and there's a question about who the lead agency was, both agencies are on the hook. Both agencies will need to have complied with the Section 106 process. State and local governments, neighbors of your project, and other interested parties can all be consulting parties in the process. And then the last one on this list is any tribe that attaches religious and cultural significance to the historic properties. That is significant because it means that tribes need to be consulted through two vehicles. If your project is on tribal land, then you need to be consulting with the THPO, the Tribal Historic Preservation Office. But even if it's not on tribal land, it's on completely private land or other federal land, if a tribe has religious or cultural ties to that property where you're developing your mine project, that's the second vehicle for a tribe to be involved. And tribal consultation is really important. It can be time-consuming. It can be contentious. If you have multiple tribes, you're talking about dealing with multiple governments, and each government has their own system and own preferences and, frankly, their own cultural way of doing things. And that's where planning well in advance in any mine project is key. Consultation is defined by rule, as you can see here on the slide. Okay, now you have all these, you've identified all the different folks who would be consulting parties for this project. And I say you, but at the beginning I said this is the agency's obligation. But, you know, an agency has limited budgets, and I think, as you know from other permitting processes, the project proponent is a big driver in keeping projects on track, and you know, you have the stake. You are, you know, in my mind, the #1 stakeholder in having a project move forward. So you have a role in helping to be sure that helping the agency comply with the law. Okay, then you have to define the area affected by the project, and it's called the APE, the Area of Potential Effects. There can be direct effects. So, for example, if you're building a mine access road, obviously the direct effects are where you blade and where you install that road. An indirect effect would be on the other side of the hill from where you put in the road. If I were sitting at, like, say, a teepee ring or some other sacred site, would I be able to hear the construction noise as you built that built that access road? Would I be able to hear truck traffic? Would dust be created that impairs air quality on the other side of that hill? Or if I'm across the valley from where you put in that road at a sacred site, would I be able to see the road and the truck traffic from the sacred site? That would be another indirect effect. So the area of potential effects includes both the areas where direct effects would occur and that area where indirect effects would occur. So you draw a big circle, or if it's a road, you may draw in a large corridor on either side. Then you want to identify the properties in that area, and that you need to do with consultation with the other parties. So, as a practical matter, you're going to hire a cultural resource consulting firm to help you do that, and they're first going to do a records check and find out what's already been identified in this area. But then you still have to talk to other people, and where tribes are concerned, consultation needs to occur early and often, and there may be confidentiality concerns because tribes aren't necessarily forthcoming with where cultural resource sites are, and particularly where sacred sites are. You know, when we shared that slide earlier of very pretty places, and we talked about history, and we talked about places that are deeply spiritual, you know, people aren't necessarily forthcoming about where their most sacred and special places are. So consultation can be difficult at this stage, even at the point of you're only trying to identify properties. Getting someone to tell you where their most special place is on the earth might not be that easy. Okay, once you've identified all the different properties that could be affected, then you need to identify if there are going to be adverse effects. This is much like identifying the type of impacts you would cover in a NEPA document. If there are adverse impacts, so for example, you're going to put in a road and there's a huge cultural site, one way to mitigate is to relocate that road. Maybe you just move it. Or if it's, say, a mine project and you're setting up your mine plan and there really is no way to move it, the minerals are where they are. You can't avoid that. But in the process of extracting those minerals, you destroy, say, a TP ring or some other type of special site. You need to figure out with the consulting parties how you're going to mitigate that. And there are a lot of different ways of doing that. Some mitigation options are just recording data, writing down what was there, taking pictures, and then sending all that data to the state repository, which is the State Historic Preservation Office. They are generally the repository for cultural resource information. In some instances, there might be an excavation of the cultural resource material, and that material then would go to an archive. Maybe someday it would go into a museum. Some instances, material has been excavated, and another mitigation option is to create educational materials. Even things like roadside signs that say this is what happened in this area and this is how cool it is, and it's like a teaching people on driving tours of the country about history. Okay, so any of these options, and there are lots of them, you write them all down in what's called a Memorandum of Agreement. That's the culmination of the Section 106 process. Or if it's a particularly complex program, then you would be using a programmatic agreement instead. And programmatic agreements really could be their very own webinar. And at the very end, regardless of whether you're using an MOA or a PA, you provide the ACHP an opportunity to participate and comment on your agreement. And they would say, we agree with this mitigation plan, or we don't, and we think that you should maybe consider all these other options. But what's important to know about the ACHP is they don't have authority to bring lawsuits themselves. They're an advisory body. So they can make your life pretty difficult, and they have certainly connections to Congress and the executive branch and provide advice through those vehicles as well. They don't have the power to deny a permit. Rather, the permit is issued by the agency that you're working with. So this is a little bit more about the tribal consultation component, and it gets its own slide because tribal consultation can be so time-consuming and it can be so contentious. And again, if you have multiple tribes, that means you have multiple independent governments that you need to work with their own rules, their own cultural practices. Just to emphasize that on tribal land, there may or may not be a TIPO. If there is no TIPO, then the tribe will need to designate a different representative for you, the company, and the agency to consult with. If you're off of tribal land, the trigger is properties of religious and cultural significance, which may again be of landscape size, scale. And in the past, those landscape scale sized areas were sometimes called traditional cultural properties, or TCPs. A lot of old literature, if you do a Google search or you want to learn more about this area of law, you'll see a lot of old documents that use the word TCP. And now, in current documents, all the agencies are moving towards just using the actual regulatory term, which is properties of religious and cultural significance. But so if you do that, if you start getting interested in this area of law or you start working in it, just know that that nomenclature has changed over time. So here's a case study number 1, and the background here, and it's hard to see because I faded it so that the text would appear nicely. But this is a geothermal area in Northern California, and a geothermal company wanted to install, go figure, geothermal energy assets. But a tribe has sacred sites throughout the area. And go figure, that the case went to litigation, and it started in California, and it's been in the Ninth Circuit several times, and the project has not yet been built. And here's the takeaway. For tribes, the government, whatever agency that you, the permittee, are working with, has a fiduciary obligation to comply with Section 106 of the National Historic Preservation Act. The federal government and every tribe have a unique government-to-government relationship, and it's not an empty formality. It continues to get traction year after year. It's real. It can't be ignored. And if an agency chooses to ignore it, or or the administrative record doesn't reflect that the agency complied, then the project can be enjoined. And here's the quote from the end of this case that's cited at the top of the slide. We conclude the agencies violated both NEPA and the NHPA. It follows that the agencies violated their minimum fiduciary duty to the Pitt River tribe when they violated those statutes. And the court goes on to say that we do not reach the question of whether the fiduciary obligations of federal agencies to Indian nations might require more. So the takeaway is that a failure to comply with NEPA or Section 106 of the National Historic Preservation Act is a violation of a fiduciary duty. It results in an injunction, and the whole project goes back to the agency for more work. And who's the greatest loser in that scenario is the project proponent. This geothermal project has yet to be built. The case study number 2, and this is a solar panel in the back, and you're like, but we're miners and we don't, what do we care about solar? This is the biggest case in recent years in Section 106 compliance, and the holding of that case applies across all industries. In this case, a huge solar project was proposed by a company called Tessera. It was the Imperial Valley Solar Project. And a tribe opposed, there were project opponents, and litigation occurred. And what the court came back with was that the agency, in this case the Bureau of Land Management, had not complied with the Section 106 regulations and had not engaged in adequate government-to-government consultation. First, the consultation didn't begin early enough. It has to begin early so that you can address the tribe's confidentiality concerns. Again, you're asking a group of people to disclose to an agency and potentially to a project proponent where their most sacred and special places are. If you came and asked me where my most special place was, I might not really want you to tell you and then have it also appear in the administrative record. So if there is a vehicle to disclose that information confidentially, which there is, that's a better route. But then where you're talking about creating a confidential agreement, that can take some additional time. This project involved multiple tribes, and the court determined that meetings among multiple tribes all together may not qualify as government-to-government consultation. Rather, this court stuck to the position that it needed to be the agency and one tribe. That may vary from tribe to tribe because some tribes may think that's appropriate, but it will vary from tribe to tribe because, again, we're talking about one government and then another government's preferences and another government's preferences. The court also was skeptical that consultation was appropriate if it occurred with agency staff or even with agency managers. In this case, the agency should have actually used the head of the agency or one of the deputies. That, again, this is consultation driven, So working with the tribe or the other consulting parties on who they want to consult with and who really represents the agency, and then documenting in the administrative record which person in the agency has the authority to consult is key. This is one point where I've seen project proponents get hung up before. As we mentioned, the agency has limited funds and limited resources, and so you, the project proponent, really end up carrying the lion's share of the work, and you likely employ a cultural resource consultant to help through the process. And that consultant can do a lot of things, can write letters, can organize meetings. The consultant certainly has the expertise to speak intelligently with other people about where cultural resources might be, what the effects might be, and how to mitigate those. But contact from a consultant to a tribe does not count as tribal consultation, because that's not contact with the agency. The same goes for having the company contact the tribe. While that is helpful and gets information out there, it should not be considered a substitute for actual government-to-government consultation. The importance of the administrative record can't be overlooked. Letters and other correspondence, letters that say, here's a map, please respond with where your sacred sites are. That is helpful to have in the administrative record. It demonstrates that the agency has reached out, but that by itself does not reflect consultation. And then there are instances when an agency actually hasn't shared sufficient information with consulting parties, including tribes, and that can be problematic as well. So you want to be sure that the agency is actually disclosing the whole project to the other consulting parties. This case, again, it's just one case. It's a district court case. Who knows where this is 3 years old now. Who knows where it would go next? But this is the gold standard for how to comply with Section 106. As soon as the case came out, the news was throughout the Bureau of Land Management, and all the agencies that we've worked with since then have looked at this case as the gold standard, and we would advise any company to similarly push for this level of consultation. Because again, the consequence here was that the court said, agency, you didn't do a good enough job. We enjoin this project and we remand it back to the agency. The impact of terminating a project at this point, and it wasn't terminated, but it was delayed indefinitely while the agency redid its process. You again reach financing problems, and this asset I know has switched hands at least once since then. It is still out there, but a solar project that would have been online several years ago has still yet to be built. Moving on to the next is ARPA. This is a really exciting one because this will bring to mind looters, because that's what the law was really designed for. The photo at the top here is Chaco Canyon. And ARPA, the Archaeological Resources Protection Act of 1979, is related and in some ways supersedes the Antiquities Act of 1906. So we have to talk a little bit about the Antiquities Act. When Anasazi ruins and other old ruins were discovered throughout the American West, go figure, a bunch of looting happened. And this also happened even in previous centuries, like the 19th century in Egypt. We've all heard about looters in Egypt as well. You find these beautiful historic sites. They're covered in mud. Someone thinks it sounds fun to, find out what's in there. It's really exciting. And they go in and they find a bunch of pottery, or a bunch of, in dry caves, they might find baskets. And then they take that stuff and they sell it. The market in cultural resources is pretty significant. It's up there with the trade in animal parts such as ivory, and it's no small part of the world economy. So the Antiquities Act, though, says, hey, you can't take stuff from cultural sites. You just can't. It's against the law. But it never had an enforcement mechanism. So in the mid-1970s, there was an uptick in looting on public land, and the Antiquities Act was ill-equipped to deal with that. So ARPA was passed, and it created enforcement mechanisms to prevent looting. And you now must have a permit for the excavation, removal, damagement, etc. of archaeological resources located on public lands and Indian lands. All right, so why are we talking about looting? Because this is a mining group, and all we do is put up projects, and we're not looters. Because ARPA can be, and in some instances is being used for criminal and civil penalties against otherwise good, ordinary projects that have nothing to do with looting. In the earlier slide, we talked about what a cultural resource is, and the very first bullet said that subject to special definitions in each statute, we had general descriptions. Well, ARPA has its own definition of archaeological resource, and the definition is here. Everything has to be over 100 years old, and it has to be capable of providing scientific understandings of past human behavior and related topics. So that's a pretty broad category. It can be pot shards, it can be arrowheads, it can be lithic scatters, it can be baskets. We're generally talking about, things that you can hold. But the buildings themselves would also be archaeological resources. You can't alter the building by, say, taking off its bricks, or certainly you're not going to destroy an old building. So, as we talked about, this is really about looting, but how does this affect miners? These are the exceptions to ARPA, and I'm going to skip through here just to get to the case study, and then we can come back. This is a hypothetical case study. It's taken from several different matters from different industries, and so I've made the hypothetical for an oil and gas company, but this could just as easily be any mining company that uses in situ processes, and certainly anyone who's doing surface excavation, this would also apply to. This hypothetical big oil and gas company, Bodco, has a multi-year drilling plan. They planned early. They had all their ducks in a row. They got all their federal permits. They thought they had all of their federal permits. They got their EIS covered. They executed a programmatic agreement. They consulted with tribes. Everything looked like it was great. And they hired their cultural resource contractor to help them with the cultural resource component of their project. Cultural resource folks come in all different sizes. You have big companies like AECOM certainly helps, but then you also have within each state smaller shops which have terrific expertise and terrific relationships within the state that can provide great bonuses for companies. There was a site in this hypothetical of a buffalo jump. So you'll see on the picture, it's like a diorama of buffalo or bison jumping off of a cliff and crashing to their deaths. And these places really do exist. The photo on the bottom is the Vor site in Wyoming. I know there's lots of pictures of Wyoming, but this is a particularly cool photo. You can see that bison were run off of this cliff to their death, harvested, but the bones are all left behind, and they were left behind for decades, resulting in this incredible pile that has since been excavated by the University of Wyoming over time, and people can go visit, and it's also used as a teaching tool for future archaeologists. Okay, so they find this big site. It's going to take a lot of time to excavate because this is not the kind of thing that you can just, record the data. This is a big deal. Provides lots of scientific information for future use. So small contractor gets its ARPA permit, because you can't do any excavation without a permit. And they get it, it's good for a year, and then it's never renewed. So the federal agency here says, hey, we're looking through our paper and we see that this little contractor hasn't had his permit renewed in a long time, but we know that they're excavating because, we're all in the loop on how this excavation is going, but there is no permit. This one little box hasn't been checked. the little box meaning, did you renew your permit? So in an enforcement action, who is the agency going to come after? That little mom and pop shop cultural resource contractor, or is it going to come after the larger big oil and gas company? Or, could be a mining company or using surface disturbance or in situ mining as well. There are plenty of unanswered questions here, but it is real that, who are we going to come after? Is there an indemnity program? Is there an indemnity agreement between that little contractor and the big oil and gas company or not? Can you actually allocate that type of liability? These are unanswered questions. And what are those liabilities? Going backwards just for a moment to civil penalties. The measure of civil penalties is the cost of restoration and repair of the resource, plus, in the event it was looted, the commercial value of those. So, the civil penalty really reflects the purpose of ARPA, which was to prosecute people who were looting. So if you took something off of public land and then you sold it and you made $1 million, we want the cost of the resource, and we want that $1 million because you can't retain a benefit for something that you took illegally. And the government can also have acquire through forfeiture proceedings any of the equipment that was used. And criminal penalties are available if the violation was knowing. And knowing can be imputed to corporations. And again, there are big questions here about how that knowledge gets imputed and whether it gets imputed. So the takeaway of this story is when engaging archaeological contractors, or if you're doing the work yourself, be sure that all the permits are there and are renewed, because you don't know if, you don't want to have to face this question of who's liable. One of the big themes, again, in cultural resources is tribal consultation or consultation with other parties, and it's the sort of highest and best use. The big takeaway is all of these require consultation. Do it well, and document it. So ARPA also has its own tribal consultation obligations. If the issuance of that permit may harm any cultural or religious site on public lands, then the agency needs to first identify any of the tribes that may have such cultural or religious ties to the site, then notify the tribe of what's going on, and then wait 30 days, consult with the tribe about any of their interests, their concerns, and develop ways to avoid or mitigate harm or destruction to the site. So while it says 30 days, it could take more than that to get through the consultation process. And then ultimately, any permit that's issued could include measures to reflect those mitigation measures that were developed between the agency and the tribe that was a consulting party. You, the project proponent, want to stay in the loop on that consultation, certainly, particularly with respect to what mitigation measures are suggested. The Section 106 process that we talked about first and ARPA do overlap. Many agencies require you to have a permit just to go out and do a survey. So, for example, you want to do your, access road, and you have to hire a contractor to go do the survey. The first thing they do is their Class 1 survey, which is a record search that says, hey, what's out there? What has already been identified in this area? And then the second is a Class 3 survey, which is a pedestrian survey, which means a group of archaeologists walking around, staring at the ground. Really, they're just staring at the ground, walking. It's kind of comical. That's a Class 3 pedestrian survey where they're actually looking for sites. They put little flags in the ground. They record where all those sites are. If it looks like there's something significant, then they get out a shovel and they do a shovel test of usually a 1 by 1 meter square. That requires a permit to do that shovel test. But in many instances, you just go ahead and get the permit for the pedestrian survey as well. In the event that you find things that need to be excavated or curated as part of the mitigation process, then you certainly need an ARPA permit for that. So that's how the Section 106 and ARPA overlap. Second, the next statute we'll talk about is NAGPRA, the Native American Graves Protection and Repatriation Act of 1990. This is a pretty straightforward statute to comply with. We want to protect cultural items excavated or discovered on federal or tribal land. So unlike NHPA, which can apply on private land, NAGPRA only applies on federal or tribal lands. Specifically, it's designed to protect human remains and cultural items related to human remains. If something were discovered, say, while you were putting in your mine access road or doing surface disturbance, if you were to find remains or cultural items associated with those remains, they would need to be returned to the right tribe. Go figure, because consultation is the theme throughout each of these, consultation has to occur to identify who gets the remains and those cultural items. And again, when we talked about what are cultural resources, the first bullet said, hey, each statute may have its own definition, and here's the definition that applies here, cultural items. There are 4 categories: human remains, funerary objects, sacred objects, and objects of cultural patrimony. Okay, I shouldn't have to define human remains, right, because that seems pretty straightforward, but I will note that there is a spectrum here. There are some courts who feel like the recently deceased don't count in this category, but certainly things that are then the other end of the spectrum is that all human remains would count. So some say not only old stuff, not new stuff, and then another end of the spectrum says all stuff. Funerary objects are pretty exciting. Anything that is reasonably believed to have been placed with the individual remains. I mean, this is going to be really inadvertent. I mean, no one, it's not like this is not like a Western movie where you're riding a horse and then you come across an ancient burial ground, right? That's not going to happen. But in the event that you are excavating something, like, for example, putting in a road or a pipeline, that's where this type of activity would happen. You may find remains, or you may find just funerary objects, or sacred objects is the next category. And objects of cultural patrimony, the definition is also provided here. So you're out there, you're putting in your pipeline, you're putting in your road, you find this inadvertent discovery. And there's no way that you could have planned for this. I mean, if you knew what was out there, you would have moved the road, moved the pipeline, or figured out a way to address it before you did surface disturbance. The first step is notify agencies, notify tribes in the area. Tribal consultation would have to occur, and then if the project were on tribal land, the tribe would need to consent to any further activity. But in this moment, the excavation of that site for your road or your pipeline or your surface disturbance has stopped. And NAGPRA then overlaps with ARPA. You can't do anything without getting an ARPA permit, which again takes 30 days at least to get tribal comment. And in the event that you choose not to comply, there are civil and criminal penalties associated with NAGPRA as well. The final sort of classic statute that we'll talk about here is Tadpa, Historical and Archaeological Data Preservation Act of 1974. This doesn't get a lot of traction because it doesn't get litigated that much, but I bring it up here because it has an overlap with the Section 106 process. The whole purpose of Tadpa is to preserve data. It applies to activities that have a permit on both public and private lands. So kind of like Section 106, this can apply anywhere if you had to have a permit. And it applies not just to archaeological data, but also to historic data. And what's the big difference here? Well, historic data is a larger family. It could apply to, like, the United States is a pretty young country, and this could apply to historic data from the 19th century railroad era. Whereas with archaeological data, we're really thinking about TP rings and Native American artifacts that might be out generally in the Western United States. So again, there's a spectrum of the type of data to be preserved. It's a larger family than what we've been talking about in the others. But this is also interesting because it only requires the preservation of data and not the stuff. So the last bullet here is where Tadpa and Section 106 of the National Historic Preservation Act overlap. Remember that one of the steps in Section 106 is to mitigate adverse effects, and there's a lot of different ways to mitigate. You can just record the information and send it to an information repository. You could excavate the material and send that to a repository. Maybe someday it gets studied by some academics, or maybe someday it goes into a museum. Or another way to mitigate might be to create educational material and a whole spectrum of things. On that one end of the spectrum was recording data. And the ACHP, the Advisory Council, has suggested that people, project proponents and agencies should follow the Tadpa requirements of recording data as one of the mitigation options. So that's the overlap. There is, however, in Tadpa one interesting twist that has a benefit to project proponents, but it has not been tested. There's a provision that when a project is taking place on private land or other non-federal land, so a state parcel, if things stop, if projects stop because you have to comply with Tadpa, then you may get compensated for any resulting delays or loss of use of the land. That hasn't been tested, but I put it out there just because it's hope out there that maybe someday someone does want to press it. And if your project is delayed, can you actually get some compensation for that delay? Because as we all know, delays are very expensive. Most states also have, I'm not going to go through every state, at least 48 have cultural resource preservation laws or other laws that incorporate cultural resources issues. And they come in all types. So Colorado, for example, has a Colorado State Register of Historic Places. Its program is very much like the National Register of Historic Places and is very similar to Section 106. In Wyoming, there are some other acts that, and this is just one example of what can exist in various states. The Industrial Citing Act requires a certain type of permit for projects that are valued over a certain amount. These are really big projects like power plants. And in the process of getting that permit for particularly expensive projects, there has to be a cultural resource survey and a consultation with the State Historic Preservation Officer. It's just one more step along the way, but I don't want to overlook, we spend so much time thinking about the federal programs for managing cultural resources. States also have their own provisions, and while we're on the topic of states, we can break it down even further and talk about local governments. There are certainly local governments that have historic preservation programs as well, and that gets really important in certain towns. When we talk about local governments, we're talking about cities and counties, and cities with particularly historic resources that might be used to attract tourism to the area. They may have particularly vigilant regulations to prevent disturbance of those areas. And while mining operations are typically far away from a town, it is something to have out there. If you're in a county that has cultural resource laws, they are important to comply with as well. We talked about NAGPRA and the inadvertent discovery of human remains and other patrimony artifacts. And there are state laws that govern similar inadvertent discoveries. Every state has its own State Historic Preservation Office. That was one of the results of passing the National Historic Preservation Act. Each SHPO has its own officer, also called the SHPO, and they each have their own personality, and many of the conflicts that we see are relationship-based. So having contractors with good relationships and having people on your team, in the permitting team, who have terrific relationships with the SHPOs can go a long way. Can go a long way in identifying properties, identifying if the effects are adverse, and certainly goes a long way in identifying what the appropriate mitigation measures. Because the whole point of having a SHPO is that they get to sign off on what was found. You want their concurrence, and concurrence is a relationship-based process, which is why I call them out here. For folks developing projects on largely public lands, and particularly BLM lands in the western United States. There is a national programmatic agreement executed by the Department of the Interior that specified, it largely adopts the Section 106 procedures that we talked about in Part 800, but they do allow for each state BLM office to adopt their own special procedures. So Nevada has a terrific example, and you can just Google it, pull it up on the Nevada BLM website, and it walks you through step by step how that Nevada BLM office wants cultural resources taken care of, how they want tribal consultation to occur, and those can be invaluable. But they do vary from state to state. And there are also memoranda of understanding with federal agencies. For example, if you have a project on Forest Service land, are they actually adopting the BLM position through a memorandum of understanding? There are a couple of related topics in the cultural resource world, and they are a series of executive orders that require tribal consultation. And I bring them up because they are getting more and more important over time. And I'll skip to this one at the very bottom. December, this is not an executive order, this is an MOU executed at the end of last year by multiple departments and the ACHP. And it's designed to improve the protection of and access to sacred sites. And no surprise, because the big theme here is consultation. Consultation meetings are ongoing, and there was one, I think, last week with tribal governments to talk and develop an action plan to continue to improve the protection of sacred sites. Let's see. The next slide is where we talk about landscape-sized cultural resources. And this is the San Francisco Peaks case, which, as I mentioned before, if you are from Arizona or have been to Arizona, this is also where the ski area called Snowbowl is. And Snowbowl wanted to take wastewater, actually sewage water, recycle it, and then turn it into artificial snow. It's Arizona, right? So, I mean, they don't get, say, as much snow as Vail, but they do get plenty. And every ski area makes snow at some point in its year. So you want to take sewage water, clean it, and then turn it into artificial snow. So your, kind of your gut reaction to that is like, well, that's kind of gross. And they actually had signs about this project that said, the snow in this area is made from recycled water. Please don't eat it. I mean, that maybe triggers in anyone's mind, don't eat yellow snow. And I thought about actually adding that sign to this, but it might not convey quite the right message. So a group of Native Americans, the Navajo Nation, in fact, objected to the project because the San Francisco Peaks area is sacred to them, and it has been sacred to them since time immemorial. So they opposed the agency, which was here the U.S. Forest Service, trying to issue a special use permit to Arizona Snowbowl to allow this project to occur. And the litigation takes all forms. It talks about violations of NEPA, talks about violations of Section 106 of the National Historic Preservation Act. And then what was novel is that it talked about a violation of the Religious Freedom Restoration Act, or RFRA. Just going to go back once more. They sued at the district court, and the Forest Service decision was upheld. Everything's fine. No NEPA violation, no NHPA violation, and no violation of RFRA. Then everyone has the right to one appeal. It goes to the Ninth Circuit, and on appeal, the tribe won. There was no NEPA violation, no NHPA violation, but there was a violation of the Religious Freedom and Restoration Act, RFRA. The government moved to have it reheard, and it was, and then the Forest Service won. they rehearing overturned the previous decision. But the reason that this is important is because that decision was 2 to 1. 2 judges said the Forest Service was in the right. 1 said it was in the wrong. When they petitioned for rehearing en banc for the whole Ninth Circuit to hear, that was denied. So there is a big question out here in the Ninth Circuit about what RFRA requires, and particularly savvy project opponents would, I think, rely on this case, and so it's good to know that it's out there. The Religious Freedom Restoration Act requires this, that the government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability, except you can burden if, 1, it's in furtherance of a compelling government interest, and 2, it's the least restrictive means of furthering that compelling interest. So that test is a bunch of legalese, really, and I don't want to go into too much detail because then we'd get into constitutional history, and that might put everyone to sleep on a Friday afternoon before the Thanksgiving holiday. But the point here is that this is another vehicle for a project opponent to say, hey, that area, that enormous area, the San Francisco Peaks, or if we're talking about, we could cite any number of mountain ranges that are sacred and deeply important to folks. They say, hey, that's part of my religion, and if you do that project, that mining project, that you're going to strip mine, you're going to discharge water, all of that stuff is really going to impact the way that I practice my religion, and I don't like that. This is another vehicle for a project opponent to get out there, and given that the area of law is a bit unsettled, this could appear in future cases in other circuits, not just the Ninth Circuit, but elsewhere. So I close with a couple of, and we'll open it up for questions, but I wanted to call out a couple of resources. There's a cultural resources chapter in the American Law of Mining book, particularly in the section for environmental compliance, and that walks through each one of these programs that we talked about today and includes additional resources, citations to all of the statutes, and gives a great overview. And then as we started the talk, I mentioned that Section 106 of the NHPA is the most time-consuming and the most expensive component of cultural resources law to comply with at this time. So I think it's important that everyone be really up to speed on how it works. So the ACHP has a great website with a lot of guidance documents and a lot of resources to walk people through how it works, including recommendations on best practices for tribal consultation. So I highly recommend that anyone who is involved in cultural resource compliance for different mining projects be familiar with that site and use it as a resource. And then because this is a webinar, I'll also point out that ACHP also has a webinar series for Section 106. It's really cheap. I think it's like $50. And then they also have live training courses, which are really valuable, and there are 2 types. There's a basic 106 and a more complicated level for special programs, kind of like including, how to develop programmatic agreements. So if cultural resources are a significant issue because of where you are where you are developing projects, any one of those training resources would be terrific. That is it, and I think I know it's 1:50. We're about quarter past. We can open it up for questions now if that would be useful.
Great. Thank you so very much, Merit. That was a lot of great information in there. And before we get into the questions, which if you have questions, please type those in now. I just want to remind everyone that we did record the webinar, and we will be aiming to get the recording as well as PDF version of the slides out to everyone, hopefully by the end of the day. Now on to the questions. On your Section 106 process slide, what if you have a private landowner that does not want their land surveyed?
That's a great question, and it actually comes up quite a bit. The big concern that I've noticed from landowners is they don't want you out there surveying, because then if you find something, they have the impression that it's going to be disclosed to the public, and they might have to open up their property for the public, or somehow the government is going to say, hey, you can't do whatever it is you want to do on your private land because you have a historic resource out there. Well, first, none of that is true. If a private landowner, if you survey something and you find something out there and you tell the private landowner where it is, the private landowner does not have to tell the public where it is. There's no restrictions on what the private landowner can or can't do with this property. But that hopefully eliminates the issue, because the agency has to comply with Section 106. So if the landowner digs in and says, no, you will not survey out here, then the agency is unlikely to be able to comply with its Section 106 obligations. That can result in the project needing to be rerouted. There are some instances where you may be able to get the SHPO to sign off on the property based on past surveys of the area. So if the property was surveyed, say, 20 years ago, and so you already knew that there was a historic barn and 5 lithic scatters and 2 teepee rings, it's possible that the SHPO would say that's enough and that we have enough information to move forward. But it's also possible that the SHPO might say, you know, our 20-year-old survey is 20 years old and it has to be resurveyed, so you have to go do it. If the landowner really digs in, that can be a showstopper. What we've done in the past is negotiate very heavily with the SHPO and the agency representatives to see if they can figure out a good solution together.
Okay. Well, that was the only question that we had come in. So if there are no others, I would like to just let everyone, remind everyone to take down Merritt's information on that last slide there. I'll also include that in the email when I send out the recording and the PDF as well. But I'd like to thank Merritt once again for putting on this great webinar. Greatly appreciate it. Thank you everyone for attending, and look forward to having you guys on the next one. Thank you very much.
Thanks everybody, it's been a pleasure.